your practice, or whether there is software that will help you do a better presentation than perhaps the old ways of having a little cardboard design of wherever the incident occurred. So the reality is that you're using technology. The competence means use technology and understand what matters for your practice. And if you're not tech savvy, as most people aren't, then it may mean that at times you need to either have an IT person or a consultant or someone to whom you can refer, because you must have that knowledge in order to be competent. You wouldn't want to go to a doctor, and if people have ever heard me speak, you've heard me say, you don't want to go to a doctor who would say, I'm not going to use those newfangled MRIs because they weren't around when I was in law school. Well, when most of us were in law school, most of this technology didn't exist, but it doesn't mean that we can ignore it. You're responsible, you have to take care of it, and that's what competence means.
I agree 100%, and I'm brought to mind of a case that's going on in New Jersey right now, Dan, involving social media, where a paralegal friended the opposing side, the opposing client in a case, and the lawyers have been brought up on charges for that, and the lawyer's response to this was, well, one, we didn't tell the paralegal to do it, and two, we don't understand how social media works. And given what you just said, clearly the court was not interested in the fact that they didn't understand how social media works. First of all, you have an obligation to manage your staff, ethically speaking, and that means you have to manage them and make sure they're appropriately trained when it comes to technology. And second of all, you have an obligation to understand. So if you're going to use the technology, you've got to understand how to use it. And as you said, Dan, there's some technology you just have to use, and I think that would include computers in general, and these days email and, electronic legal research. You can't get away with doing book research anymore. There are all these sorts of things that you have to use, and for social media, I think that a lot of the time, if you're not aware of the rules behind when you may and may not communicate with people online, and when it's crucial to look at potential evidence and how you access it. For example, if you're a personal injury defense lawyer, insurance defense, and you're not looking at the publicly available information on someone's social media account, you might be committing some malpractice there, because the reality is that people post all sorts of harmful information that disagrees with what they say publicly to the court or to their lawyers or to you. So they might, for example, say, well, I'm too depressed to leave the house, and then they're posting about going to parties on social media, right, Dan?